Afternoon, good evening, depending on your time zone. And welcome to the Honourable Justice Charles D. Gonthier Memorial Lectures and His Excellency Judge C.G. Weeramantry International Justice Award, a very high point of the international law biennial for Canada and indeed the world. I'm Advocate Carter Chang, Assistant Manager and a PhD researcher of the University of Cambridge, and I'll be one of your Master of Ceremonies.
Hello and welcome to all of our participants. I am Dr. Tejas Rao, CISDL Senior Manager, Coordinator of the DEMED Global Program at the University of Cambridge, and a postdoctoral scholar. Together with Advocate Carter, it is my pleasure to introduce the chairs of our 2026 Gonthier Memorial Lectures and Weeramantry International Justice Awards, which also serve as an official side event to the 2026 High-Level Political Forum. Professor Marie-Claire Cordonier Segger, Chair in Sustainable Development Law and Policy at the University of Cambridge and CISDL Senior Director, has already been introduced in the opening of the symposium. I will simply highlight that as a world-leading scholar and highly distinguished jurist in the field of sustainable development law and governance, she holds the chair in Sustainable Development Law and Policy at the University of Cambridge, Lucy Cavendish College, also serving as the Senior Director of the Centre for International Sustainable Development Law. She has been elected Fellow of both the UK's Royal Society of the Arts and the Royal Society of Canada, one of Canada's highest academic honours, and last night received a Global Sustainability Leadership Award 2026 in the UK House of Lords. Among other honours, she is a laureate of the prestigious HE Judge C.G. Weeramantry International Justice Award. The Honourable Elizabeth Maruma Mrema, Assistant Secretary General of the United Nations and Deputy Executive Director of the United Nations Environment Programme, has also been introduced. So I will simply use this opportunity to highlight that she has served for many years at the highest levels of international environmental governance and is also a laureate of both the Q International Award and the HE Judge C.G. Weeramantry International Justice Award. Honourable Elizabeth Maruma Mrema and Professor Marie-Claire Cordonier Segger, thank you for chairing this special session of the symposium. The floor is yours.
Thank you so much, Dr. Tejas Rao. It is a true honor to co-chair this session. We gather at a moment of profound consequence for people and planet alike, as the triple planetary crisis of climate change, nature loss, and pollution presses hard upon the most vulnerable among us. Yet, as my colleague and co-chair, the Honourable Elizabeth Mrema, often says, in our distinguished global community, we can find genuine cause for hope that law wisely shaped may safeguard both human dignity and the living earth upon which all rights depend. Warmest of welcomes to the 2026 Honourable Justice Charles D. Gonthier Memorial Lectures and His Excellency Justice Christopher Gregory Weeramantry International Justice Awards. It's a profound privilege to gather with you for what, each time, is among the most moving occasions of our biennial symposium, one that unites addresses by world-leading scholars and jurists with heartfelt celebration, honoring the legacy of two early and eminent mentors whose lives gave enduring meaning to international law on sustainable development. In today's age of great fragility and uncertainty, there's a quiet grace in pausing to remember those who taught us that the law, at its finest, may serve responsibility, sustainability, and justice for generations yet to come. We begin with the Honourable Justice Charles Gonthier Memorial Lecture, established in memory of a jurist whom we were honoured to call the first chair of the Board of Governors of our small centre here at McGill in Montreal, and who, after 17 years' distinguished service on the Supreme Court of Canada, returned to his alma mater as Senior Wainwright Professor at the McGill University Faculty of Law. In recognition of the enduring importance of his work for current and future generations of Canadian and international jurists, this lecture illuminates how international civil and constitutional law alike may advance global justice and sustainable development worldwide. Now, to help us to open this special celebration, It is my pleasure to invite our Masters of Ceremony to share welcoming remarks that have been graciously provided by video address from the new Dean, Professor Tina Piper of McGill's Faculty of Law.
Bonjour et bonsoir à tous et à toutes, où que vous soyez dans le monde. It is my privilege to welcome you, on behalf of McGill University's Faculty of Law, to this Memorial Lecture and International Justice Award session. C'est un honneur, au nom de la Faculté de droit de l'Université McGill, de vous accueillir à cette séance commémorative et à cette remise de prix. McGill's connection to this occasion runs deep, and it is one that gives our faculty enormous pride. The Center for International Sustainable Development Law was founded by McGill alumni, and so many of its fellows first found their calling for international law within these halls, before carrying that training out into courts, tribunals, and ministries around the world. Voir cet héritage se poursuivre année après année est exactement ce qu'une faculté de droit espère accomplir. We are especially pleased, too, by how naturally this occasion sits alongside McGill's own traditions, our long-standing commitment to legal pluralism, to bijurism, and to training jurists who move fluently between legal systems and languages. Cette approche pluraliste et bijuridique propre à McGill trouve un écho naturel dans la démarche mondiale et transsystémique du CISDL en matière de droit du développement durable. We gather also to honor the memory of the Honourable Justice Charles D. Gonthier, a distinguished graduate and longtime friend of this faculty. Le juge Gonthier, par sa jurisprudence sur l'équité, la solidarité et le bien commun, demeure une référence fondamentale dans notre enseignement de droit, et sa générosité envers les jeunes juristes est encore chaleureusement célébrée ici. Alongside him, we remember His Excellency Judge Christopher Weeramantry, whose vision of law in service of sustainable development and intergenerational justice continues to inspire jurists the world over. It is fitting, then, that McGill stands beside CISDL today as we celebrate both these legacies and the laureates and global fellows who carry them forward. Nous sommes fiers de voir notre réseau d'anciens rayonner aussi loin et de savoir que les valeurs cultivées ici continuent de façonner le droit international et le développement durable du prétoire à la table des négociations. On behalf of the entire faculty, thank you to CISDL, to our co-organizers, and to everyone joining us today. Au nom de toute la faculté, merci au CISDL, à nos partenaires et à vous tous. Je vous souhaite une séance riche et inspirante. Have a great day.
Merci, Madame la doyenne. C'est vraiment une inspiration de vous écouter et de savoir que notre faculté est ici avec nous et derrière nous aussi en appuyant cette occasion. It's now an honor and a pleasure to welcome two leading Canadian judges, the Honourable Judge Sebastien Grammond and the Honourable Justice Mahmud Jamal, who have kindly agreed to provide opening remarks, addresses in this special occasion. Juge Sebastien Grammond has served on Canada's federal court since November 2017. Previously, as a renowned and beloved professor and dean of the civil law section in the University of Ottawa, his world-leading research focused on Indigenous identity, Indigenous legal systems, and contractual justice. As author of over 6 books and numerous articles on Indigenous law, constitutional law, and contract law, he has received numerous prestigious awards, including the Méritier du Barreau du Québec and the Mundell Medal for Excellence in Legal Writing. We will now hand the floor to the Honourable Judge Sebastien Grammond to help open this important occasion.
Thank you, Marie-Claire. So it is a privilege for me to welcome everyone to the 2026 edition of the Charles Gonthier Memorial Lectures. And Charles Gonthier was a renowned jurist, lawyer, and judge. He was Justice of the Supreme Court of Canada from 1989 to 2003. He was a man of wisdom, rigor, and vision. He truly mastered a broad range of legal areas from civil law to constitutional law, and he knew that the law could not be divorced from the broader moral and ethical imperatives governing human conduct. I had the occasion to meet him when I was a law clerk at the Supreme Court many years ago, and I remember a complex civil law case that none of us knew what to do with. And when his draft judgment was circulated, it was a masterclass in legal reasoning. And now, a few years later, the Supreme Court handed down its judgment in the Quebec secession reference. And although it was an anonymous judgment, it bears Justice Gonthier's mark in that it deftly combines principle and pragmatism. And I would say so much so that both sides claim victory. And in a nutshell, the court discouraged unilateral action, and rather it said the constitutional change should be negotiated and take everyone's interests into account. And the law does not prescribe the outcome. Now, these lessons remain relevant today in the Canadian national conversation and perhaps internationally as well. Now, it is thus fitting that these biennial lectures celebrate Justice Gonthier's legacy. Each time the speakers remind us how he can be a source of inspiration for using law to address the most pressing issues of our times. Thank you.
Thank you, Honourable Judge Sebastien Grammond, for your highly meaningful insights. Further, we are deeply honoured to be able to welcome the Honourable Justice Mahmud Jamal. Justice Jamal was appointed to the Supreme Court of Canada in 2021, and prior to his appointment, he was a judge of the Ontario Court of Appeal with a deeply distinguished career as a renowned litigator, specializing in constitutional law, administrative law, and commercial litigation. He previously also served as director of the Canadian Civil Liberties Association and as a former law clerk to Justice Charles Gonthier at the Supreme Court of Canada. He joins me in celebrating the legacy of a remarkable jurist who guided and mentored us both. Honourable Justice Jamal, the floor is yours.
Well, thank you very much, Marie-Claire. Honoured chairs, distinguished guests, participants from around the world, good afternoon or good morning. Bonjour à toutes et à tous. C'est un grand privilège de vous adresser quelques mots à l'ouverture de ces conférences données en mémoire du juge Charles Gonthier. As Justice Grammond has already stated, Justice Gonthier was a jurist of rare wisdom and humility, and in his later years he devoted himself to international sustainable development law. The values that these lectures honour, judicial independence, the rule of law, and principled reasoning, were the values he lived by. It is in that spirit that I'd like to say a few words about why these values matter so profoundly in the world we now live in. As we all know, we live at a turbulent moment. And around the world, the rule of law is under strain. Courts face pressure that is political, popular, and at times deeply personal. International institutions are being tested. And the defining challenges of our age, climate change, mass displacement, inequality, and the erosion of democratic norms, respect no border and yield to no single jurisdiction. In such times, judicial independence is not a professional privilege. It is a public trust. A judge who decides without fear or favour, guided only by the law and by conscience, is one of the surest guarantees that power will remain answerable to principle. In our increasingly interconnected world, when judicial independence is weakened anywhere, the protection it offers is weakened everywhere. La primauté du droit, elle aussi, exige davantage que que de beaux principes. Elle exige un engagement partagé entre les citoyens, les gouvernements et les tribunaux. Et elle nous rappelle qu'on ne peut pas parler des droits sans parler également des responsabilités. Principled legal reasoning is what holds these commitments together. It is the discipline of deciding hard questions openly, transparently, and with humility, of following the law where it leads, even when the path is unpopular or inconvenient. In an era of easy certainties and loud voices, a patient, reasoned humility may be the rarest and most necessary judicial virtue of all. And here, I believe there is genuine cause for hope. International law is rising to meet these challenges. In recent years, international and domestic courts and tribunals have begun to give real legal content to our shared obligations towards our planet and towards one another. Jurists around the world are drawing on each other's reasoning as never before. And our conversations today are part of that same global effort. Ces échanges entre juges, universitaires et praticiens de partout dans le monde sont précisément la raison pour laquelle je demeure optimiste quant à l'avenir. It is now my privilege to give the floor to today's distinguished speakers, who will explore how our courts and international law can safeguard human rights, advance sustainable development, and uphold justice in turbulent times. Thank you for your attention, and I look forward to a rich and rewarding discussion.
Merci beaucoup, Justice Mohammed Jamal. We are truly delighted to share special video remarks from Her Excellency, the retired Honourable Madame Louise Arbour, Governor General of Canada. Madame Arbour has had a truly distinguished career in international law and human rights, including as the Chief Prosecutor of the International Criminal Tribunal for the former Yugoslavia and Rwanda, as well as the United Nations High Commissioner for Human Rights and Justice of the Supreme Court of Canada. Her remarks on the importance of international human rights do carry particular weight and meaning today. If we can then please play her video address.
Dear friends, we are at a critical moment in the pursuit of justice, both internationally and in every national jurisdiction. The Universal Declaration of Human Rights is the most important document of the last century and a turning point in the modern world. And it has been the foundation of a better life for millions of people. Across cultures, religions, and political affiliations, it articulates the essence of our humanity and the fundamental ways in which our interactions with each other must protect it. For years, the challenge was, for the most part, one of implementation. This is no longer the case. The promise of equality, security, and a decent life in greater freedom for all is more elusive than it has ever been in the recent past. Paradoxically, we have access today to more information, more rapidly, and on a greater variety of subjects than ever in our history. But we have also developed unimaginable ways of distorting reality, empowering malevolent forces intent on destroying democratic pursuits. It is this loss of a common ground that is maybe the greatest threat to the promise contained in the human rights instruments that are anchored in the Universal Declaration. There is no safe prescription for reversing this trend. But a young generation is rising, equally concerned, better educated, and extraordinarily connected. I believe that they will, as they must, stand up to denounce discrimination, to fight for equality, to assert their right to speak and use it in support of those who can't, and to act in solidarity for the well-being of the planet and the fundamental rights of all its inhabitants. There is no greater call to action no more inspiring project today than to stand up for human dignity. I have immense faith in those who are coming after us to adapt to a new reality, what has been for many of us the project of a lifetime. Thank you for your kind attention.
Thank you, Your Excellency, Governor General Louise Arbour, for these deeply moving remarks, inspiring us all. Now it is my distinct honor and pleasure to introduce our 2026 Honourable Justice Charles Doherty Gonthier Lecturer. His Excellency Judge Professor Dire Tladi is a judge of the International Court of Justice appointed in 2023. He is also one of the world's most foremost international law scholars, having served for many years as a member of the United Nations International Law Commission, including as its chairperson, and having authored many important volumes, including several to which, in his kind, charming, and brilliant manner, he persuaded many of us, including myself, to contribute. He is also a distinguished professor of international law at the University of Pretoria and has been a leading voice on matters of international law and human rights from the perspective of the most vulnerable and voiceless communities who still have agency to struggle for a better world. His contributions to the codification and development of international law on topics as diverse as jus cogens norms, crimes against humanity, and the protection of persons in the event of disasters have shaped our discipline for generations of scholars and practitioners worldwide. Your Excellency, Justice Professor Tladi, the floor is yours.
Merci, merci, esteemed collègues, les juges, Excellences, all participants. Merci infiniment à Marie-Claire. Merci à toutes et à tous. Tout d'abord, je voudrais dire que je suis très heureux d'être ici avec vous, même si en ligne, de partager plusieurs mots dans cette conférence. Mais je suis en particulier très honoré de donner le Honourable Justice C.D. Gonthier Memorial Lecture. Alors, merci à le Centre de droit international du développement durable. For my contribution this evening, I would like to say a few words about the multiple challenges and crises facing the world and the urgent need for action. Today, the globe faces many challenges and crises. Everywhere we look in the globe, there is a conflict. And just while you're focused on that conflict, another one erupts, pushing the conflicts that you're looking at to the background. We're facing a planetary destruction of enormous proportion, whether one is speaking about the climate change crisis, loss in biodiversity, the ailing health of our ocean, and poverty that scar on humanity's claim to be humane, humanity's claim to humanity, in fact, well, that continues also unabated. I would have liked to discuss all of these issues, especially the issue of poverty, but of course, we only have so much time, and so I will focus on the climate change issue in order to make a much broader point, which is applicable really, at least from my perspective, to all of these issues. Is there anything that international law and the system that's created around it, by it, can do? Is there any point, to use the words of Marie-Claire, is there any point in hoping for a better future? In answering this question, I would say there is an interesting trend which has been noticed by many, and which some might suggest that there is still some hope, some modest hope perhaps, in international law and its institution. This trend is the turn to the courts, including and in particular, the turn to the International Court of Justice, the court of which I am a member. There is, I think we all know by now, there has been a remarkable increase in the workload of the court. The International Court of Justice. In fact, I would like to refer to a remark that one judge in the 1970s once quipped that he, in his first 3 years at the court, donned his robe only once. Well, I can tell you that within my first month at the court, I had put on my robe around 10 times. This turn to the court, and in particular, a turn to the International Court of Justice, might be a reflection, or so the argument might go, that states and people more broadly trust the court and therefore still trust international law. I say people more broadly because if you think about the climate change cases, the climate change related cases that we've had in recent years, it's not only states that are behind these, but also civil society. The recent climate change advisory opinion of the International Court of Justice, to which I will turn in a moment, was, as we know, spearheaded by a group of young people from the Pacific Islands. So, faced with this climate crisis, 3 different organizations and groups of states, completely independent of each other, approached 3 different international courts with the related question of the obligations of states in respect of climate change. What is more, these requests were made within a period literally of a few months of each other. But what does this tell us? Does this tell us that the court and international courts more generally are trusted and that there is a belief in international law? And if so, is this belief in the courts and international law warranted? The answer to the first question is a little more complicated, but in the interest of time, I will assume that the answer is yes, or I will take that answer for granted. So states and people more broadly trust the court and therefore still have some faith in international law. But then this raises the second, and for the purpose of this lecture, the far more important question: is this trust and belief in the courts and the law well-founded? The Inter-American Court, the one court which was approached with the question, was, as to be expected, shall we say, ambitious. And here I'm avoiding the terms progressive and conservative, which often tend to be prejudicial to a discussion. And of course, the Inter-American Court did not disappoint. It identified at least some parts of the right to the environment, for example, as use cogent. And of course, I'm simplifying this, again, in the interest of time. The International Tribunal for the Law of the Sea, the first of these courts to render its opinion on climate change, also gave what can be described as a robust and ambitious opinion. But again, this was nothing surprising given its track record, including in relation to the responsibilities of states advisory opinion of 2011 and the Sub-Regional Fisheries Commission advisory opinion of a couple of years ago, of about a decade ago. The real wild card was the International Court of Justice. Many, and myself included, expected the court to deliver a less than robust and less than ambitious advisory opinion. But it did not. It gave an opinion that was extremely ambitious. And what's more, it did so while staying true to its mandate to apply the law. And again, allow me here to digress and to refer to another great, Judge Weeramantry, who in his dissenting opinion in the Nuclear Weapons Advisory opinion, warned that progression did not have to come at the expense of a rigorous scrutinization of what he termed every available source of international law, quarrying deep, if necessary, into its very bedrock. I will point very quickly to 3 examples of the ambition that we can find in the International Court of Justice, but I want to emphasize that even though I point to these 3 examples, there's many more that I could have pointed to. The first example of ambition is the court's identification of the right to the environment as a right under international law. In fairness to some of my colleagues, let me be open about the fact that the court does not say this in a way, or at least let me say the court does say this in a way that some might see as ambiguous. I don't agree. I don't think that the court was ambiguous. The court was certainly not explicit, but I think the court was not ambiguous. It is clear from the court's reasoning that the court sees a right to the environment as a right under international law. The second way in which the court's advisory opinion can be seen as ambitious is in respect of the interpretation of the Paris Agreement, and in particular Article 2.1 of this agreement, which relates, of course, to the temperature goal. As you know, the Paris Agreement refers to 2 temperature goals, the more ambitious 1.5 degrees Celsius and the less ambitious 2 degrees Celsius. The court, applying its customary rules of interpretation and taking into account scientific consensus, does something that neither ITLOS nor the Inter-American Court of Human Rights does, which is to say, under the Paris Agreement, the legally relevant temperature goal is the more ambitious one, when it was more likely to have said is the least ambitious one. The third example of ambition in the court's advisory opinion is the manner in which it interprets Article 4.2 and the so-called nationally determined contributions. As you might know or not, the court determines that, contrary to a commonly held belief, the NDCs are not at the sole discretion of the state, and that their adequacy falls to be judged and evaluated. Again, I have to stress that the court comes to this conclusion on the basis of a reasoning and the application of its normal rules of treaty interpretation. Now, I come back to the question that I started with, and I say that based on this, you might say, well, the three courts have all given ambitious and robust opinions, even the International Court of Justice, from which robustness and ambition were not expected. And so they delivered on this front. Therefore, you might say that there is indeed trust in the court, and that this trust and faith in international law is well justified. And here I wish to offer some words of caution. And again, the International Court of Justice reminds us of this. And with your permission, I wish to quote from the court's advisory opinion. The court says, towards the end of its advisory opinion, the questions put to it by the General Assembly are legal ones, and the court, as a court of law, can do no more than address the questions put to it through and within the limits of its judicial function. This is the court's assigned role in international legal order. However, the questions posed by the General Assembly represent more than a legal problem. They concern an existential problem of planetary proportions that imperil all forms of life and the very health of our planet. International law, whose authority has been invoked by the General Assembly, has an important but ultimately limited role in resolving this problem. A complete solution to this daunting and, quite frankly, self-inflicted problem requires the contribution of all fields of human knowledge, whether law, science, economics, or any other. Above all, a lasting, satisfactory solution requires human will and wisdom at the individual, social, and political levels to change our habits, comforts, and current way of life in order to secure a future for ourselves and those who are yet to come. Unquote. I think what the court is saying here is no number of judgments, no number of opinions can help resolve this multiple crisis that I have referred to. So not just the climate change crisis, all the other crises that I spoke about. Only actions from decision makers. This paragraph, from which I've quoted at length, makes clear that it is not only politicians that are the addressees, though. You and I are also addressees. We bear some responsibility, both in terms of our conduct, but also because ultimately we are responsible for the politicians that we elect. In that same advisory opinion, I ended my own individual opinion on a bittersweet note, and again, with your permission, I wish to quote from it. I said, a solution to this problem requires those in decision-making positions to make the right choices for the sake of the future of our planet. The truth is that what you invest in reveals what you value. Currently, based on reported military spending compared to spending on other issues of international concern, such as the environment and global poverty, it seems that those who are in a position of authority value war over the plight of humanity and the future of our planet. I still maintain modest hope that those in positions of power will realize before it's too late that money cannot be eaten. Modest hope that future generations will make better choices. On this note, I thank you very much.
Thank you very much, Your Excellency, Judge and Professor Dire, for a lecture at once profoundly inspiring and also finely considered, dare I say, ambitious. You have given our audience, gathered from every corner of the globe, a great deal to reflect upon, enriching the intellectual and deeply humane legacy of our mentor, the Honourable Justice Charles Gonthier, and honoring the esteem in which all of us here today hold you and your colleagues in the world's highest court. across a remarkable career from your years of service and chairmanship in the UN International Law Commission to your scholarship on questions as fundamental as the peremptory norms of general international law and the protection of the most vulnerable, you have given voice to those too often unheard and helped shape the very conscience of our discipline. In its recent and courageous advisory opinion, as you note, on the obligations of states in respect of climate change, handed down unanimously in July 2025, the entire International Court of Justice affirmed that a healthy environment is a precondition for the enjoyment of human rights, and that states do bear binding obligations to protect the climate system for present and future generations, to prevent our territory from being used to harm others, and to cooperate in the context of sustainable development in particular. That the world's highest court should speak with such clarity in a moment of profound planetary urgency offers all of us, scholars, practitioners, and leaders alike, renewed courage to believe that international law may yet rise to meet the defining challenges of our age, even as the court correctly identifies the need for all humanity to take action worldwide for future generations, far beyond the law. Now, I understand from our team that nearly 3,000 people from over 120 countries have registered for this symposium, and that more than 1,600 have already joined us online, in person, over these last few hours. Dr. Tejas and Advocate Carter, as our Masters of Ceremony, you've been carefully monitoring our online forums for comments. Please, dear colleagues, would you like to share some reflections from our wider audience worldwide?
Absolutely. Thank you very much, Professor Cordonier Segger. So to consolidate from Tabriz Sheikh of India, Ibrahim Buhari Yunusa from Nigeria, and Matilda Paulson from the United Kingdom, who all reflect on how inspiring it has been to hear directly from judges and leaders whose work has influenced international law across generations. They say that the reflections have reinforced the importance of integrity, independence, and service, and discussions so far have demonstrated that sustainable development is not only a policy objective, but also an evolving legal principle that increasingly guides judicial decision-making around the world. Carter?
Absolutely. Thank you so much, Tejas. So Faisal Sawa from Ghana, Ghosh from India, and Kevin Swift from South Africa highlighted that today's session celebrates more than remarkable careers. It also celebrates the enduring idea that law, when guided by integrity, independence, and compassion, can serve both people and the planet. And at a time when the world faces increasing complex challenges, these lectures and awards reminds us that principled judicial leadership remains indispensable to peace, sustainable development, and the rule of law. Thank you.
Thank you. It is truly remarkable to see the engagement and inspiration with these legacies worldwide. I will now turn to my colleague and now increasingly dear friend, the Honourable Elizabeth Mrema, WIJA, to help lead the second part of this very special celebratory occasion.
Thank you. Thank you very much, Maria Claire. His Excellency Judge C.G. Weeramantry International Justice Award was created in memory of a respected and honored international judge, professor, jurist, and mentor, and that is Judge Weeramantry. The late Judge Weeramantry served society and its most vulnerable members as a judge and vice president of the International Court of Justice. As an eminent jurist and a scholar, the revered professor and mentor, esteemed trustee of those without a voice, renowned humanitarian and advocate for peace and education. He served as founding patron of the Center for International Sustainable Development Law, as well as a founder of the Weeramantry International Center for Peace, Education, and Research. As laureate of the UNESCO Prize for Peace Education, the Right Livelihood Award, and many other honors, his work was recognized worldwide. Throughout his efforts, he was supported by his beloved, darling wife, Mrs. Rosemary Weeramantry. As a laureate of the Weeramantry International Justice Award, it is my pleasure to introduce two distinguished speakers to deliver memorable remarks. One is Professor Nico Schrevejen, who is a distinguished emeritus professor of public international law at Leiden University, and he has served as a member of the Senate of the Dutch House of Parliament. He has authored numerous influential works on international law, including The Evolution of Sustainable Development in International Law, and another one, Sovereignty over Natural Resources. Professor Schrevejen has served as president of the International Law Association and has been recognized with several awards for his contribution to international law, including the prestigious Hague Prize for International Law, as well as the Weeramantry International Justice Award. Another one is Advocate Neshan Gunasekera, who is a lead counsel, peace, justice, and governance at the Center for International Sustainable Development Law. He's also a visiting fellow at the Royal Wellmeg Institute. Advocate Gunasekera received the Weeramantry International Justice Award for his work in justice and inclusion, particularly in Sri Lanka, through the United Nations and globally through his leadership of the Weeramantry International Center for Peace, Education, and Research. He has also worked significantly with the World Future Council, of which he was a founding member. Professor Nico Schrevejen, if we could first turn, I could first turn to you, please. Let's hear from you. Professor Nico.
Yeah, thank you very much. Un grand merci à tous vous. It's really a great pleasure to participate, and especially under the leadership of you, Elizabeth, and you, Marie-Claire. And I would like to use this to say a few words on the footprint Judge Weeramantry left on the jurisprudence of the ICJ. And I do so with reference to the advisory opinion on the legality of nuclear weapons, which is now exactly 30 years ago delivered. And this week we had in The Hague an interesting commemorative event on that. In fact, this advisory opinion, as rendered on 8 July 1996, marks the first time that the court, the ICJ, took up environmental issues and international environmental law in a judicial decision, just 1 year ahead of the Danube Dam, one case later, which also took up the issue of sustainable development as a legal concept. No doubt, Judge Weeramantry had a major hand in navigating the court, addressing the environmental impact in both cases, especially in the advisory opinion on the use of nuclear weapons. The court, of course, did not go as far as Judge Weeramantry wanted the court to do, but he certainly pushed the court in that direction. In Weeramantry's view, it was inescapable that the court has to deal with principles of environmental protection because, I quote the judge, they are so deeply rooted in the conscience of mankind that they have become particularly essential rules of general international law. And he added, violation of which in certain circumstances has been postulated as an international crime, unquote. Obviously, the court itself did not go that far, but the pioneering way in which the court took up international environmental law and put it as a relatively young chapter in 1996, only 20 or 30 years old, next to established chapters, older chapters, such as international humanitarian law and the law of warfare, that was certainly innovative and rendered a major boost to the full recognition of international environmental law as a fully fledged chapter of public international law. For example, the court concluded, I quote, "The existence of the general obligation of states to ensure that activities within their jurisdiction and control respect the environment of other states or of areas beyond national jurisdiction is now part of the corpus of international law relating to the environment." End of quote of that advisory opinion in 1996. And as you know, the court also gave an interesting definition of the term environment and opened the door for the principle of intergenerational equity and the protection of the environment in times of armed conflict. These and other points are all elaborated in great detail in the dissenting opinion of Judge Weeramantry, who was happy with the direction the court took, but he was of the opinion that the court had to go further. Something, and that is interesting to note, which finally happened in the fascinating advisory opinion on the obligations of states in respect of climate change. And this opinion of July 2025, which we have been addressing today, builds on the environmental elements of the nuclear weapons advisory opinion as introduced by Judge Weeramantry, and certainly also on what was in 1996 a dissenting opinion, but what is now largely a unanimous opinion on sustainability and equity. So see here a prime example of the footprint of our pioneering and admirable Judge Weeramantry. I thank you very much for your patience, Elizabeth. Back to you.
Thank you very much, Professor. You have put it rightly that the legacy we remain to remember Judge Weeramantry is what was taken up last year. Many thanks. Allow me now to turn to Advocate Nation Gunasekera to give us his few thoughts. Nation, over to you.
Thank you, Madam Chair, for that kind introduction. It is an honor to be present today, and thank you again to Professor Marie-Claire Cordonier Segger, my dear friend, for this kind invitation, and importantly, for this shared journey of weaving now spanning over 2 decades. Our respected Professor Shriver just wonderfully articulated some of the key jurisprudential inspirations that our dear Judge Weeramantry has left to our generations to ensure that we pass it on to generations yet to come, so that we may together realize his dream of universalizing international law. Let me now share with you all 2 personal reflections on this important occasion as we also celebrate the 100th birth anniversary of Judge Weeramantry. The first reflection is, of course, of great importance to me. This is a message of a love, mutual respect, and integrity that both Judge Weeramantry and his beloved wife, Rosemary, shared with all the young ones, including myself, throughout their storytelling days. Judge Weeramantry would lovingly recount in his memoirs that it was because of Rosemary, who stood by him for over 5 decades, that he was able to achieve everything in his life. My second reflection goes to the memory of Judge Weeramantry receiving the UNESCO Peace Education Award in 2006. Sharing it with wonderful people like Mother Teresa and many others. This nomination was a fascinating story where over 11,000 children from the largest school in the world, the City Montessori Lucknow, nominated Judge Weeramantry. And then the activities that I had the great honor of leading at the Weeramantry International Center for Peace Education Research was also mentioned in this award. In many ways, His Excellency Judge C.G. Weeramantry International Justice Awards and His Excellency Judge C.G. and Rosemary Weeramantry Fellowships are a weaving of their collective wisdom and achievements. Thank you.
Thank you very much, again, from the perspective of the legacy we've been left behind by late Judge Weeramantry in terms of underlining the importance of education and research. Many things. So thank you, both of you. Allow me now to turn our attention to more or less completely different, important issue now. And here it is my pleasure to introduce two eminent experts who will announce this year's laureate of His Excellency Judge C.G. Weeramantry International Justice Award, as well as the winners of the 2026 Global Fellowship. Are you ready? So Professor Damilola Olawi is a laureate of the Weeramantry International Justice Award. He's also a UNESCO Chair in International Law and Sustainable Development at Hamad bin Khalifa University in Doha. He's also the Vice Chair of International Law Association. The other person I have the honor to introduce is Professor Judge Marcel Nzabo, who is a justice for the Constitutional Court of Hungary and a full professor of Pazmany Peter Catholic University, and is likewise a laureate of the Weeramantry International Justice Award. So, Professor Olawi and Professor Nzabo, please go ahead. Let me begin with Professor Damilola Olawi.
Thank you very much, Honourable Elizabeth Maruma Mrema. The Commission received over 350 applications from around the world from promising early career scholars in the field of international law and governance on sustainable development. And after very difficult deliberations, concluded on the following candidates. As gold commendations from the Commission, it is a great pleasure to recognize Advocate Kera Sofia Cascante from Costa Rica and Advocate Nurul Uda Angriani from Indonesia. Congratulations to you both. For our 2026 Global Fellowship, we are delighted to award Dr. Katalin Solyok from Hungary and look forward to working with her over our tenure of the next 2 years. I will now pass it on to Professor George Marcel Nzabo to announce the laureates for the Weeramantry International Justice Award.
The Weeramantry International Justice Award is granted to distinguished senior-level jurists whose life works, intellect, and character offer the highest possible credit to the memory of His Excellency, the late Judge Christopher Gregory Weeramantry, recipient of the UNESCO Prize for Peace Education Right Livelihood Award, laureate and former Vice President of the International Court of Justice. We are delighted to announce that the Weeramantry International Justice Commission has selected the 2026 laureates as follows. It is a great pleasure to announce the 2026 His Excellency Judge C.G. Weeramantry International Justice Award laureate, Honourable Ralph Nijenvanu of Vanuatu. The Honourable Minister Ralph Nijenvanu has long stood at the intersection of governance, justice, culture, and climate leadership. Through his public service and his principled advocacy, he has helped place the voice of small island states and vulnerable communities at the center of international legal and political debate. Most notably, his leadership in advancing Vanuatu's historic climate justice initiative at the United Nations has helped catalyze one of the most significant contemporary efforts to clarify the responsibilities of states in relation to the climate crisis. In this, he reflects the spirit of Judge Weeramantry's legacy, a deep commitment to future generations, a belief that law must serve humanity and the planet together, and the courage to insist that justice must be made real in the world. We warmly congratulate Honourable Ralph Ijenvanu on this most deserving recognition. Her Excellency, the Right Honourable Louise Arbour, it is a profound honor to announce the 2026 His Excellency Judge C.G. Weeramantry International Justice Award laureate, His Excellency the Right Honourable Louise Arbour, now Governor General of Canada. The Right Honourable Arbour's distinguished career has exemplified the highest ideals of international justice, human rights, and the rule of law. As a jurist, prosecutor, and international leader, she has served with exceptional integrity and force of intellect, helping to shape the protection of human dignity across some of the most difficult legal and political questions of our time. Her work has consistently reflected the values Judge Weeramantry held so deep: courage in the service of justice, fidelity to the rule of law, and an unwavering concern for the rights of vulnerable and the dignity of all peoples. It is therefore especially fitting that she receives this recognition in the centenary year of Judge Weeramantry's birth. We offer our heartfelt congratulations to Louise Arbour. His Excellency Judge Professor Dira Tladi. It's a great honor to announce the 2026 His Excellency Judge C.G. Weeramantry International Justice Award laureate, His Excellency Judge Professor Dira Tladi of South Africa. Professor Tladi is one of the leading international legal minds of his generation, combining distinguished scholarship with exemplary public service. His work on international law, state responsibility, and the relationship between law, justice, and sustainable development has helped shape the field with clarity, depth, and principled purpose. As a jurist and scholar, he has consistently advanced a vision of international law that is both rigorous and humane. He stands in a remarkable line of international lawyers whose work reflects Judge Weeramantry's own conviction that law must be engaged with the pressing realities of the world and must always remain attentive to justice, equity, and the interest of future generations. We warmly congratulate Judge Professor Dira Tladi on this rightly deserved honor. Many congratulations to you all.
Warmest of congratulations. First, of course, to Dr. Catalin Souliok, who I think can join us on the screen, and then especially to my new colleagues, the Honourable Ralph Ijenvanu of Vanuatu, the Honourable Louise Arbour of Canada, and His Excellency Judge Professor Dira Tladi of South Africa. Congratulations and welcome to our most deserving laureates. This is truly a prestigious honour, and we warmly welcome our new laureates to the Commission and the broader Sustainable Development Law community worldwide. To conclude, we are delighted to share messages from Professor Advocate Romesh Weeramantry, who represents the family in the awarding commission, and Advocate Pierre Gonthier, who is part of choosing every biennial the Gonthier Lecturer. Professor Advocate Ramesh Weeramantry is, of course, a prominent international arbitrator and senior legal advisor with expertise in international investment law and arbitration, co-founder of the Asian International Arbitration Center, and a cherished governor of the CISDL. And Advocate Pierre Gonthier is also CISDL governor and treasurer, as well as executive director of the Sustainable Aviation Fuel Consortium, where he leads initiatives to advance sustainable aviation fuel technologies and promote environmental stewardship in the aviation industry. Both have kindly sent brief messages to celebrate this special occasion. May I please turn to our Masters of Ceremony, Dr. Tejas Rao and Advocate Carter Cheng, to share their very brief video addresses.
From Australia, I send my most sincere congratulations to all the experts, leaders, scholars, and students gathered for this important and inspiring international symposium on the intersections of human rights, sustainable development, and the law. The urgent challenges and the remarkable solutions you are debating today are as critical as ever at a time when multilateralism and the rule of international law face both monumental tests but at the same time, great opportunities. You are all to be commended for your foresight, your commitment, and your leadership. Now, this year holds a particularly significant milestone. My father, His Excellency, the late Judge Christopher Gregory Weeramantry, would have celebrated his 100th birthday this year. It's a centenary that calls us to reflect with gratitude and renewed purpose on the extraordinary life he lived, the ideas he championed, and the world he sought to build. There is perhaps no more fitting occasion on which to announce and celebrate the laureates of the H.E. Justice C.G. Weeramantry International Justice Awards, honouring the legacy of one of international law's most beloved and enduring champions. Born and raised on the shores of Sri Lanka, my father was known as one of the earliest and most vocal champions of the need to protect future generations and to secure global sustainable development through international law. His life, his works, and his tireless personal efforts have inspired generations of bright young minds, including many gathered here at your symposium today, to advance the interests of current and future generations in international law. As a role model, my father showed us the importance and the profound potential of international law as a force for positive change in the world. Throughout his lifetime, Judge Weeramantry served society and its most vulnerable members with unwavering dedication. First, as an advocate and professor, he devoted his energies to defending the voiceless and nurturing young legal minds. Then, as judge and thereafter as vice president of the International Court of Justice, and subsequently as laureate of the UNESCO Prize for Peace Education, founder of the Weeramantry Centre for Peace Education and Research, and patron emeritus of the Centre for International Sustainable Development Law, he revealed himself as an eminent international jurist, a humanitarian of world renown, and an unstoppable advocate for peace. All this incredible work could not have been possible without the sustained and inspiring support of my beloved mother, Rosemary Weeramantry. Through my father's landmark opinions on the International Court of Justice, he brought the concept of sustainable development into the living heart of international law, issuing what has become a well-recognized invitation to the law, and then laying down the legal pathway for advocates to advance the rights of all peoples and of nature itself interconnected for current and future generations. Through his charitable works, his prolific writings, and his gentle yet insistent public engagement, he advanced sustainable development in countless ways, tirelessly seeking to create a better world for those who will inherit its fragile planet and its many vulnerable peoples. It is therefore deeply moving, and I think deeply fitting, that in this very centenary year, we have witnessed his legacy continue to bear fruit in the most consequential of ways. The International Court of Justice's landmark advisory opinion on climate change and its advisory opinion on the right to strike have each carried forward ideas and principles that my father spent his life advancing. In particular, the obligation of states to protect the environment for present and future generations, the indivisibility of human rights and sustainable development, and the role of international law in giving voice to those who would otherwise go unheard. My father dared to argue these things decades before they were widely accepted, and today they are finding their expression in the highest pronouncements of international law. He would have been, in his usual quiet and humble way, deeply gratified, and he would already have been looking ahead to what comes next. In this centenary year, and on behalf of the Weeramantry family, I'm deeply moved and truly thrilled to invite you to celebrate and cherish his legacy during today's symposium, and to carry it forward every day in your work, your scholarship, and your endeavours in the world beyond.
Thank you. And Dr. Tejas, would you also be able to play the brief video from Advocate Pierre Gonthier?
Distinguished judges, Your Excellency, honored laureates, esteemed colleagues, dear friends. As we bring this remarkable ceremony to a close, it is my privilege on behalf of the Center for International Sustainable Development Law and the Gonthier family to offer our heartfelt congratulations to the 2026 laureates of the HECG Weeramantry International Justice Awards and the recipient of the HE Judge CG and Rosemary Weeramantry International Law and Sustainable Development Global Fellowship. We also extend our sincere thanks to every speaker, chair, partner, volunteer, and participant who has joined us today from around the world. Together, you have made this gathering a fitting tribute to two extraordinary legacies. My father, Justice Charles Doherty Gonthier, believed profoundly that the law must be guided by ethics, responsibility, and service. Throughout his distinguished career, he reminded us that justice is not measured solely by legal doctrine, but by its ability to uphold human dignity, strengthen communities, and promote stewardship of our shared environment. Judge Christopher Gregory Weeramantry embodied a similarly inspiring vision. His lifelong commitment to peace, human rights, sustainable development, and international justice demonstrated that the law can be a powerful instrument for protecting both present and future generations. His work continues to inspire jurists, scholars, and practitioners across every region of the world. Today, we have celebrated individuals whose leadership reflects these enduring ideals. At a time when humanity faces profound environmental, technological, and geopolitical challenges, their example reminds us that principled, independent, and courageous legal leadership has never been more important. As we leave this ceremony, may we carry forward not only the inspiration of today's lectures and awards, but also the responsibility they represent. Let us continue to strengthen the rule of law, advance human rights, foster international cooperation, and work together towards a more just, peaceful, and sustainable future. On behalf of the CISDL board, congratulations once again to all our laureates and fellowship recipients. We look forward to seeing the continued impact of your work in the years ahead. Thank you very much.
We are deeply grateful for these heartfelt sentiments by Professor Advocate Ramesh Weeramantry and Advocate Pierre Gonthier, and indeed also grateful to all those gathered with us worldwide online today. I see over 350 of you, for helping us to honor the legacies so cherished by our entire international law and governance community worldwide. With warmest of congratulations, appreciation, and welcome again to our new laureates and to our new Global Fellow, as well as our 2 Gold Judges Commendation winners, we now draw to a close the 2026 Honourable Justice Charles D. Gonthier Memorial Lecture and the His Excellency Judge C.G. Weeramantry International Justice Awards. I noticed that your nameplate has already been replaced with one that gives you your subnominals, and it is wonderful to see this. We have been reminded this hour that the finest jurists do not simply draft or interpret the law. They guide and inspire us all to expand the horizons of integrity, solidarity, and sustainability, entrusting to those who follow a discipline more courageous than as we found it. In celebrating our new laureates of the Weeramantry International Justice Awards and our new Global Fellows, we take up that flame, sheltering and carrying it forward together. It is fitting then that we now turn to themes that lay at the very heart of Judge Weeramantry's own vision, the rights of the generations yet to come and of our living earth itself. In just a few moments, we will be gathering for our final plenary on realizing Indigenous rights, intergenerational justice, and rights of nature. We so warmly look forward to seeing you there online. Thank you.